specifically for attorneys who refer clients to listing agents or counsel clients about residential real estate transactions. I believe people think about selling their home, and realtors who want to protect their clients. This is a talk for you. And it's sort of the beginning of a series. I had a few questions. People didn't quite get where I was going. And so this is the big domino in terms of Russell Brunson's marketing ideas, in terms of story writing, television shows. One of the biggest devices is this changes everything, or that happened. It changes everything. In terms of analysis of real estate transactions, in terms of what listing realtors can do and what attorneys must do, the fact that buyer agent compensation is no longer the listing agent's money that he or she is sharing, it's part of a separate contract, that changes everything. It changes the analysis. It is so fundamental to the transaction that when an attorney understands what I'm saying, they're not going to be able to unring the bell. They will not. If you follow this video today, you will understand that as an attorney who refers clients to listing agents, you're only going to have two choices. You either do the legal work yourself, or you will refer your file to a broker attorney who can do it properly. If you're a realtor and you really want to offer concierge level service to your sellers and you want to have a business going forward, you will bring an attorney who can help the seller. Not an attorney with your brokerage who's representing the brokerage, but an attorney who's actually available to answer the client's questions about this onto your team. Because frankly, you should not be selling a home unless your client's been counseled on the risks that your forms, I'm a broker too, and a realtor, my forms and my process cause sellers. So I'm now going to switch to the presentation. I will have the words here are worked with ChatGPT, but I'll talk I can't just read a script. So I'll be talking while we're looking at this. So let me click over this. Today we got this working. I'm actually going to go to this format for now. Maybe I'll come back to a bigger size later. So this is the domino that changed everything. And we'll go to the next slide. Oh, went too fast. Okay, so buyer agent compensation is no longer negotiated and no longer paid by the listing agent. It starts off as a contract between the buyer's agent and a buyer. The buyer's, according to MLS rules, the buyer agent must get the buyer to agree to their level of compensation before they even show the seller's home. So the seller puts it on the MLS. If there's realtors showing that home, those realtors must have a contract signed with the buyer, and the amount of money must be in writing. It is, and we've seen it's either 2.5% or 3%. That's not the law in California. The law is much less. The law in California is basically saying the amount of money that the buyer agent is going to make does not have to be written in until the purchase offer is being executed. But the MLS rules are that a realtor cannot show your client's home unless they've agreed to ask, and it's been consented to the amount of money they're going to get paid, and they've learned to ask, and they're trained to ask for the max. So they're going for 2.5% and 3%, almost invariably, from my experience in talking to realtors. So now that's a major change, because in the past, the listing agent asked for 5 or 6% and said, I will share half or whatever percentage they decided on the MLS, and they put that in writing. It was the listing agent's money to share, and consequently, when the lawsuits happened, the lawsuits were against the brokerages. They sued the listing agents and the brokerages for setting buyer agent commissions, for causing the prices of homes to be escalated, for buyers not realizing that they were actually paying their own agents out of their own money, as the DOJ said, for compromising the fiduciary duty of the buyer's agents, or at least they were at risk of that, and for steering. And I can tell you, nothing's changed about the process. In fact, steering, and I'll explain this further, but steering is now it's institutionalized. It's baked into the forms and the process, because now we know that the buyer and the buyer agent already have a contract in which the buyer has agreed to pay the agent. And we know the buyers are going for big money 99% of the time. So when a seller gets faced with a contract and they have to decide whether to pay the buyer agent compensation, anybody, a lawyer or a realtor, even though they're probably not supposed to talk about it, they're going to say, if you just counter that out right now, there's a chance the buyer is going to have to walk away, because the buyer is on the hook for paying 2.5% or 3% to their buyer's agent, and no buyer is going to want to pay that out of their pocket. They'd rather use the money on down payment for a better home or to fix the floors. Very few buyers are going to say, oh, you don't want to pay $30,000 on $1 million home. Don't worry. I not only have the 20% down payment, I have another $30,000 to pay my agents. That's just going to be such a rare scenario that every seller should know if they counter to zero, especially in the beginning, the buyer can walk. That's kind of the implicit threat in this whole form setup and negotiations. Buyer agent compensation went up in 2025 from the last reports we saw from Redfin and some other places that I spoke with in other videos, in part because in the past, if a seller was concerned about commissions, the listing agent might go down to 4% and then only offer 2%. So the seller was able to negotiate commissions or show their concerns by negotiating with a listing agent. Now it's not the listing agent's money. It's totally between the buyer and the buyer's agent. It's a third-party contract, and then they check a box where it becomes a third-party beneficiary clause in the contract. They check a box and say, please pay the seller, Mr. Seller or Mrs. Seller or Ms. Seller, will you please pay the buyer agent 3% or 2.5% or whatever they request. So now it's the seller who has all the liability for compromising the fiduciary duty, for steering, for keeping commissions high, maybe for the buyer saying, I didn't realize that I was paying my own agent and therefore they were charging too much for the home. Like all the parts of the class action suit, it's been sort of geniusly shipped over and the risk put on the seller. And the DOJ acted like the risks are still there. They stated in the no-slug MLS pin case, in their second memo to the court, they said that these new rules aren't really changing the system. The risks are still there. So now the seller has those risks. And it's obvious. If the seller is paying a percentage-based compensation to a buyer's agent, the seller is incentivizing that third party's agent in that if the agent has their seller pay more, the agent's going to get paid more. In other words, in a multiple offer situation, if they say, by the way, you should probably pay $100,000 more, if the contract goes at that price, the agent just made $3,000. So they're incentivizing buyer's agents to have their buyer pay more. So that's a risk right there. Can it be mitigated? Of course, with an attorney's help, with education of the buyer and the attorney's help, with a waiver, with an acknowledgement. It can easily be fixed. There's multiple ways. I think you can eliminate the risk 100%, but it's there. So because it's no longer the listing agent's money, it's a whole new ballgame. Additionally, well, now let's go through this. Okay, so it changes the legal analysis. And what seems like you're an attorney, you refer your clients to a listing agent. You're like, I've been doing this for 20 years. It's all been good. Well, in the past, it's all been good because the listing agent had the power to negotiate buyer agent compensation and had the risk and had to mitigate all those risks. It was the listing agent's money that was being negotiated. So it was sort of a concurrent negotiation. There was the price in terms of the home, and then there was buyer agent compensation. And some of that negotiation was stunted. No, I would say more it was modulated because of realtor ethics, but nevertheless, especially in short sales or when there wasn't a lot of money to go around, the listing agent could negotiate with the buyer's agent to have buyer agent compensation go down. Listing agents can't do that anymore. They're not licensed. They're not attorneys. They can't represent. Like this is a third-party contract. It's a third-party beneficiary clause. It's asking for the money. Listing agents aren't licensed to represent their sellers in those types of negotiations. They're also not written. There's no written authorization to do it. The DOJ forced the California Association of Realtors to remove all forms related to buyer agent compensation. So even as an attorney, which I highly suggest you do, or you put an attorney on the team who's ever going to be negotiating buyer agent compensation, they need a written authorization. And as an attorney, if you're going to be doing the work, and I think you should, I mean, you can be, and I can help you do the work, you're entitled to probably $10,000 or up to 50% of the listing agent's compensation because you're now doing the work that listing agents should be doing but cannot because of the way CAR set up these forms and because of these class action lawsuits. So who am I to say this? I'm an attorney and a broker in California. As a broker, I've sold over 200 homes all over the state. I've had offices in we sold homes from Sacramento Orange County, LA, Riverside, and San Diego, mostly in San Diego. I am an attorney since 91. I'm a broker since 2004. I've advised as an attorney and referred out hundreds of transactions. As I said, I've sold 200 homes. And interestingly, it's not like I'm just new to the game. Carr has had me train realtors on how to negotiate multiple offers. Back in the day, Carr had me train realtors on how to properly conduct short sales. So this analysis comes from an actual practice. And I can also, well, we're not going to get into what works best, but I did test my theories out and we developed 9 multiple offers. And I did watch as the price of the home got closer and closer to fair market value. I watched buyer agent compensation get negotiated away in a very transparent process. Sort of if you read all these class action suits, sort of what the DOJ was hinting at in terms of transparency. So buyer agent compensation is no longer negotiated by the listing agent. As I said, they don't have the forms, they don't have the license, there's no written authorization. I don't see how they can get on the phone and represent the seller. There's just nothing there. Their forms were removed. It's not their money. I know they're still doing this sometimes, but they're practicing law without a license, which I'll get to in a further video. I'll go over the Sipper case. It's actually cited by the Department of Real Estate, and it basically says that realtors cannot choose the form. Like I can't choose whether to bifurcate buyer agent compensation into 2 separate contracts or 2 separate negotiations. They cannot. They can act as basically scriveners. If they can put facts in like addresses and numbers, but they're not. I mean, I was taught in my training they're not allowed to cross any words out on a contract. They can't cross words out. So I have no idea how the blank forms on a counteroffer they're writing in. I don't know what they're writing in sometimes. I imagine most of the time they're just being passive and having the seller pay it. I don't know how they're writing in, without being lawyers, they're writing in terms that could counter out box G3. I really don't understand it in light of the Sipper case. I mean, it's criminal. It can be criminal. My view of it is if they're affecting third-party contracts by writing language into these forms, well, we'll let other people examine that, but I don't know how they're doing it. But they're certainly doing it wrong, in my opinion. They should never let the negotiations happen all on those lines. Those lines should be used for price and terms of the home, and should be a separate form. You can provide it, but a separate form that educates, lets the seller say, you want us to pay buyer agent compensation. We're doing it as a convenience to you. You understand that this money, because money is fungible in terms of economics, it can be said, and plaintiffs have said it, that they didn't know their money was being used to pay the buyer's agent. We want you to acknowledge that your money is being used to pay the buyer's agent, and we'll prove it because, and this might not be a hoop you want to jump them all through, but you could say, you understand that you could have negotiated a 2.5% lower price rather than pay your buyer's agent, but we're doing it as a convenience to you. And you can do that with the other risks too. So, if you're paying full buyer agent compensation and the buyer agent wants to get paid and the buyer wants to ask, I don't see why the buyer agent wouldn't jump through those hoops. And I don't see why a buyer wouldn't either. And there's many ways you could do this. That's just the idea. So it basically, everything's changed because it's no longer the listing agent's money. The old money was broker-centric. The old way was broker-centric. The listing broker went in. They said it's 6% commission. We're going to share it. That to some degree probably insulated the sellers during these class action suits, because who's going to say the seller was responsible when it was really they didn't want to pay 6%. They got the listing agent went in and pre-negotiated the big commissions. Now, because everything's been changed, there's a massive role for the attorney in these transactions. Now, I believe, as we just said, there's many places for an attorney in this transaction. First of all, the seller needs to be educated on the risks of paying buyer agent compensation. There are reasons to pay. I would advise most sellers, unless they're getting multiple offers, unless we know what the price of their home is because it's a subdivision, unless we know it's a very strong market, most sellers should probably at least consider paying buyer agent compensation. But they should be mitigating the risks, and they should be determining how many hoops they want the buyer to jump through in terms of how much risk mitigation is done based on what's going on in the market. If there's a lot of showings, if there's some offers coming in, I think a seller, the seller can play for more money or more protection. If this is the only offer they're going to see for the next 6 months, well, they're probably going to tread lightly, even on the risk mitigation, and just take their chances, depending on how risk averse they are, how much, every seller's different. That's what you'd have to find out what their desires are and help them mitigate the risks, because you can mitigate these risks from virtually 100% down to substantial. And there's a lot of different hoops, a lot of different levels of mitigation a seller could choose. And consequently, if you're going to pay buyer agent compensation, I see no reason to not do some protection. This is how it works now. The buyer and the buyer's agent agree to pay the buyer's agent some number ahead of time. Then the buyer typically will check box G3 in the purchase and sale contract, which is amazing because the contract is helping the buyer get their buyer agent paid. This box is checked, but the listing agent has no forms or language to protect the seller and break out this into two separate negotiations and advise the seller of the risks. And frankly, if they allow the seller to pay, there are risks. When the seller just listed with the agent and said, "Please sell my home," no risks. But when the agent is using contracts that are in a process that keeps buyer agent commissions high and forces them to do the stuff that California law doesn't require before they even see the property, it really, the buyer's most vulnerable. They want to see the property before they can make any decisions. And now they're locked into this massive agreement, a massive compensation that they almost all will have to have the seller pay. I mean, it's just designed to keep commissions up. And yet on that form, they can check that box. And yet the DOJ took all the forms related to buyer agent compensation from the seller. Like, I don't see how a listing agent can hold themselves out as saying, "I'm fully competent to sell your home without an attorney." It's a breach of their fiduciary duty to even pretend that when you think this through. And the fact that they cannot mitigate the risks, it absolutely should be an addendum that says, "I advise you to speak to an attorney before you sign my listing agreement or before you agree." I mean, because of the timing, like what if you got offers the first day? It really has to be before, because it could take time for them to talk to an attorney after, and the property goes up on the MLS and the offers are coming in, and they haven't even figured out their positions, their risk aversion, what they're risking, how much they want to sell for, what's going on. I mean, really, there should be a form that says you must speak with an attorney before you sign my listing agreement because of these risks. If you're going to offer buyer agent compensation, you should be prepared to mitigate it. You should know how you're going to respond. You should know that I'm not competent to get on the phone and negotiate buyer agent compensation because I don't have written authorization, because I'm not a lawyer, so I can't represent you. I don't have language to properly bifurcate the contract. I really can only sell the home in this very passive way of letting the offers come in and then say, "Why don't we negotiate the price of the home?" I cannot leverage buyer agent compensation by broadcasting ahead of time. So I can't protect you from suits by protected classes saying you were offering inconsistent buyer agent compensation with my process. But if you had the mitigation, you talk to a lawyer, we could broadcast buyer agent compensation. And that in and of itself, the way you broadcast it could actually mitigate some or all of these risks. But I can't do that because I can't help you. I can't advise you. So, like, I can't help you get a higher price. I can't help you get more showings the way I used to. I basically can allow the contract to come in and then say, "Well, let's just negotiate the price of the home," because I really am not licensed to do anything with this third-party beneficiary clause, and I'm not competent to bifurcate this contract so that you, even within, like, there's the overall idea, the probabilities are, if you broadcast buyer agent compensation, we're prepared to mitigate. You could get multiple offers, and you could have the buyers negotiate against each other. And if your listing agent was licensed to represent you in these third-party situations, they could talk to the people about reducing their buyer agent compensation if they wanted to be the strongest bidder. So they can't do that, and that's a fantastic way to do things. And then even on a one contract basis, they're not set up so that they put pressure on the buyer's agent to realize, hey, I better get this closed quickly and closer to the seller's terms, because if I keep fighting and keep this price low, at some point because they've already made it into separate contracts. I know they're going to come back and say, I agree to these terms, but we're going to negotiate down the buyer agent commissions. So, the seller is either going to sell for a higher price or they're going to negotiate buyer agent compensation down. The probabilities are if they bifurcate the contract. Realtors can't do that. It's absolutely, a lawyer needs to be involved here just to help the seller sell for more and be protected. So it's the liability shift, right? Think about that. The DOJ and the listing agents got sued for $1.6 billion, and now what these contracts seem to have accomplished is they're just shifting the risk for compromising the fiduciary duty of the buyer's agent and for steering and even the commission fixing and the prices being too high. They've just shifted all that liability onto the seller. And no one's telling the seller this. It's radically changed, and nothing about those forms. There's no forms in there saying, by the way, if you pay buyer's agents, you're taking on liability all you have to do is read the DOJ and the class action suits. The most cleanest day one possible is compromising the fiduciary duty of the buyer's agent. I've done videos on that. The fact it's not being mitigated is stunning, and people are going to get sued. It's just going to happen, in my opinion. Seller never agreed to take on this sort of liability when they asked an agent to help them sell the home, and no one told them. So we've got third-party beneficiary exposure that amounts to steering risk, potential for discrimination with the inconsistent compensation. That goes away. When I was speaking to the AI to make these slides, they split that out. They shouldn't have. Compromised fiduciary duty of the buyer's agent, uncounseled seller exposure. Let me just say what I've been saying. Breaching the fiduciary duty of the buyer's agent, steering, price fixing, commission fixing, keeping the price too high, seller not acknowledging that the source of the buyer agent compensation is from their own money. And it's uncounseled and unexplained. So a listing agent allowing their seller to pay buyer agent compensation is breaching their fiduciary duty. And if they even respond, they're on that blank form, I would argue that's because they're choosing to respond and keeping it all in one form rather than bifurcating, which is obviously good. You could just say that's an obvious track. I could break this out. By not doing it, they are choosing. It's a legal choice. They're practicing law, in my opinion, my strong opinion. So what agents can't fix it. I don't even think I need to cover this anymore. We've hammered that. So, now that you know it, the bell cannot be unrung. Luckily for attorneys, I'm suggesting there's two paths. You could come up to speed on all this, and it's not, you could probably do it across 4 or 5 files, maybe 3. Some of you that have been referring contracts out to agents, brokerages, you could probably do it right away. I probably just explained enough to you. But I suggest that if you counsel your seller well from the beginning, and there's cool forms that I've created to introduce that. I'm going to have to end this because I got to go to a soccer game. My daughter's. You can either do the work yourself and therefore I think be paid without violating RESPA and getting illegal kickbacks, and you're going to finally be paid your fair share of $10,000 or for the legal work, maybe up to 50%. That's your fair share on these files, and it's not a RESPA violation. I've got the experience to say that. So I think even the level of experience I have selling homes, I can tell you what the legal work is worth. And there's many other things you could counsel on disclosures and the contract itself. There's so much legal work that should be being done that easily $10,000 on every file, but probably more. Now, you could do that yourself, or you could do it with a listing attorney broker who was coaching you along the way. You were protecting your client. You came up to speed. You did the work. You got paid. You could do it on your own with your favorite realtor, or there's like a combination. You could bring in a listing attorney broker and he could co-broke it with your favorite broker. So there's a lot of things we can do. If you want to find out more, just go to listingattorney.com. Thank you.